Smithtown Planning Board is now in session. Would you join us?
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We thank you. Please.
Good evening, Mr. Chairman and members of the board. The first item on the agenda, the Planning Department recommends the following items for adjournment as we have insufficient information to act upon them. Part 1, Item 1, number 2011-10, Anthony Lettieri. Item 2, number 2011-01, All Seasons Motor Lodge. Item 3, number 2010-06, KVC Holdings. Item 4, number 2009-05, FB4 Realty. Part 2, Item 5, number 1066, Greenbelt Estates. Item 6, number 1059, Prestige Estates. Item 7, number 1000A, Soundview Estates. Item 8, number 773, Scholar Estates. Item 9, number 922, Sesame Estates. Item 10, number 1053A, Berg Estates. Item 11, number 911A, Glen Hill Northern. Part 3, Item 13, the 280A application of Olivia Estates. Part 4, Item 14, number LOI-5, the letter of interpretation for the Polish National Church. Mr. Chairman, these are the items the Planning Department recommends for adjournment.
Thank you. Is there anybody here to be heard on those items to be adjourned? Hearing nothing, a motion, please.
Mr. Chairman, I make a motion to adjourn the items read.
Second.
All those in favor?
Aye.
Aye. Opposed? So ordered.
Mr. Chairman, the next item on the agenda, under Part 3, Item 12, number 1046, Bel Air Estates. Mr. Chairman, we're not sure at this time if the applicant is present here. We don't know if there's someone representing the applicant.
Well, they were notified.
Yes.
I know it's been posted. So the rule is, if they're not here, we don't hear it, correct?
That's correct. We don't have an affidavit of posting, so technically the board's not supposed to hear it without the affidavit. So
Okay.
I think we have to adjourn.
Well,
it,
we'll
or-
postpone it until we see if they show up at the meeting. Maybe they're just late.
Okay,
Okay.
we'll hold it till after the next one, okay?
Okay.
Move on.
Mr. Chairman, the next item on the agenda under Part 5, Item 15, number PR number 1, Brent J. LLC, transfer of development rights. Mr. Chairman, this application was brought before the board at the December 21st, 2011 Planning Board meeting, at which time we did not have a SECRA determination from the Environmental Department. We do now. There are some minor changes within the memorandum, so if it pleases the board, I will reread the entire memorandum. Pursuant to Section 323 of the Town Code, the applicant is proposing to transfer 2.25 density flow rights from a parcel with Suffolk County Tax Map number 37-2-16.4, known as the sending parcel, to the above-referenced 53,670 square foot or 1.23 acre parcel, known as the receiving parcel. In August, the Planning Board issued a letter of interpretation determining there to be 3 density flow rights available on the sending parcel. The proposed transfer would allow the applicant to operate a gymnastics center in Building 1 on the receiving parcel. The proposed sending parcel is located on the south side of Overton Pass, 426 feet east of Three Sisters Road in St. James. The property is an irregularly shaped 144,378 square foot or 3.3 acre lot with a single-family dwelling and a detached garage with an apartment above, zoned R21. Approximately 2.2 acres of the site is steep slopes. The sending parcel is identified on the transfer of density flow rights map as being within a sending district. The proposed receiving parcel is located on the north side of Main Street in Smithtown, 307 feet west of Edgewood Avenue. The site is zoned neighborhood business and is developed with 2 buildings. Building number 1 is 11,800 square feet, and was previously used as a retail store. The applicants propose to use 10,100 square feet of the building to operate a gymnastics center. The remaining 1,770 square feet will be used for retail. Building number 2 is 6,850 square feet and is used as a real estate office. According to the applicant, the maximum allowable sanitary flow on the receiving parcel is 805 gallons per day, and the proposed flow with the proposed gymnastics center is 1,475.1 gallons per day. The proposed receiving parcel is not located within a mapped receiving district. The Planning Department has reviewed the application for compliance with Section 323 of the Town Code and has found that the proposal meets all of the standards described in 323-10 for the transfer of density flow rights. The applicable standards are described below. No transfer of density rights shall be approved without written authorization from the Suffolk County Department of Health Services. The Planning Department has received notification from Suffolk County Health indicating that they have authorized the transfer of 2.25 density flow rights from the sending parcel to the receiving parcel. A separate deed conveying the sending parcel to the town of Smithtown or another governmental or land trust organization approved by the town board, or deed restriction, that is conservation easement or declaration of covenant and restriction, must be filed for the affecting sending area before rights are sent from that property. The applicant has drafted a declaration of covenants and restrictions that states that the sending parcel shall be delineated and designated as open space, shall remain as open space for the express purpose of protecting the aquifer and water supply, and shall be kept in its natural state in perpetuity, excepting only property maintenance activities as may be appropriate to effectuate the foregoing purposes without impairing the essential nature and open character of the premise. Once the town attorney approves it, the covenant will be filed with the deed to the sending parcel in the office of the Suffolk County Clerk. No transfer shall be approved unless the reviewing board determines that it is consistent with a comprehensive plan as described in Section 263 of Town Law. The proposed change of use and the preservation of environmentally sensitive land as open space are consistent with the town's comprehensive plan. The total flow on each receiving parcel shall not exceed 2 times the flow that would otherwise be permitted if no density flow rights were transferred. Based on the information submitted with the application, the maximum flow that would be permitted if no density flow rights were transferred is 805 gallons per day. The proposed transfer would allow a flow of 1,476 gallons per day, 134 gallons less than the double density limitation. If the sending parcel is in a sending district, the rights may be transferred to a receiving parcel outside of a receiving district. The sending parcel is in an undeveloped parcel that contains slopes greater than 15%, and therefore, pursuant to Section 323-4, is considered to be within the sending district. As a result, density flow rights from this parcel may be transferred to a parcel outside of a receiving district. If the sending parcel or receiving parcel is located within the local waterfront area as defined by Chapter 151 of the Town Code, the transfer shall not be approved unless the town board determines that the transfer is consistent with the local waterfront revitalization program. On December 13, 2011, the town board adopted a consistency determination finding that the proposal to be consistent with the LWRP. On December 21, 2011, the planning board approved the proposed transfer. However, it was brought to our attention that the approval was premature because the Department of Environment and Waterways had not yet reviewed the application pursuant to SECRA. The Department of Environment and Waterways has since reviewed the proposed transfer and has recommended that the Planning Board issue a SECRA negative declaration, determination of non-significance. Based on the information presented above, the Planning Department resubmits its previous recommendation that the Planning Board approve the transfer of 2.25 density flow rights from Suffolk County Tax Map Number 37-2-16.4 to 76-2-33.1 and offers the following resolutions for the Board's consideration. Be it resolved that the Planning Board of the Town of Smithtown hereby declares itself lead agency on this matter and finds that this matter is subject to the State Environmental Quality Review Act and is classified as an unlisted action pursuant to SECRA. And be it resolved that the Planning Board of the Town of Smithtown, after due study and deliberation of the subject record, does hereby issue a SECRA negative declaration, determination of non-significance, an EIS is not necessary. In the matter of the application for transfer of density flow rights, number TDFR-PR-1, Brent J. LLC, for the following reasons. A, the proposal does not appear to significantly threaten any unique or highly valuable environmental or cultural resources as identified in or regulated by the Environmental Conservation Law of the State of New York or the Smithtown Town Code. B, the proposal will result in the preservation and perpetuity of a parcel of land which contains environmentally sensitive lands, that is, steep slopes. C, the receiving parcel does not appear to contain any high groundwater conditions, poor soil properties, or unmanageable slopes, which would impose severe environmental development constraints upon the subject proposal. D, the receiving parcel is located within the Nissaquag River Wild, Scenic, and Recreational Rivers System Program Corridor. An adverse impact upon this significant resource is not expected, as the proposal has been reviewed and approved by the State of New York Department of Environmental Conservation, the agency responsible for the administration of the Wild, Scenic, and Recreational Rivers System Program. E, the small size and nature of the proposal mitigate against a significant adverse impact upon the environment. F, the proposal appears to be consistent with the planned use of the subject parcels and compatible with neighboring land uses. And G, the proposed adaptive reuse of the receiving parcel will be subject to further site plan specific review and approval. And be it further resolved that the Planning Board hereby approves the transfer of 2.25 density flow rights from Suffolk County Tax Map Number 37-2-16.4 to Suffolk County Tax Map Number 76-2-33.1 and authorizes the issuance of a TDFR certificate upon the Planning Department's receipt of a copy of the filed covenant. Mr. Chairman, this is the Planning Department's recommendation for the TDFR application of Brent J. LLC.
Thank you. Is there anyone here representing the applicant?
Representing the applicant, I agree with all of the statements made by Blaze in the memo.
Okay. Is there anybody else in the audience that wishes to speak on this application? I see that there's two motions required then for the approval. One is for the seeker and one is for the transfer. Okay. Any other questions by the board? None? Hearing a motion for the seeker.
In the matter of TDFR PR number 1, Brent J. LLC, motion to approve the secret negative declaration as recommended by the Planning Department.
Second.
All those in favor?
Aye.
Aye. Opposed? So ordered. On the transfer and the covenant.
In the matter of TDFR PR number 1, Brent J. LLC, motion to adopt the resolution as recommended by the Planning Department and issue a TDFR certificate upon the Planning Department's receipt of a copy of the filed covenant.
Second.
All those in favor?
Aye.
Opposed? So ordered.
Thank you very much.
You're quite welcome. Have a good evening. Are you with the, we've been looking for an applicant. What? Okay. The people in the back, you're not with that first application that we were looking for somebody. Okay. All right. Let's get on then with the letter from Mr. Tramarko.
You want to adjourn Belair, or do that at the end?
You want to, no, you want to do it on the record?
Do you want to wait until the end of the meeting before adjourning it, or would you rather do it now?
Well, we can,
The adoption of the minutes yet.
Yes.
the what?
You have the adoption of the minutes first.
Okay. All right, the adoption of the minutes for January the 18th.
Mr. Chairman, I make a motion that we adopt the minutes for January 18th, 2012.
Second.
All those in favor?
Aye.
Opposed? So ordered. All right, a motion to adjourn for the correspondence.
Motion to adjourn.
Second?
Second.
All those in favor?
Aye.
Opposed? So ordered. All right, on the correspondence.
Okay.
Mr. Chairman, should we adjourn Bel Air on the record, or should we,
You didn't open up the public hearing, so,
so there's no reason to adjourn it?
no.
Okay.
We're going to treat this, because there was no show, as if it was not heard, and it'll have to be reposted again.
Do you want to make a recommendation or maybe visit the site?
All right, on the letter from Mr. Tramarko.
That's the one on Sesame.
That's him. That's him.
Any questions there by the board?
He's here.
We just adjourned the meeting, though. I don't know if we...
Okay.
The gentleman that just come in, are you here for?
Bel Air. That's Bel Air. The one.
We're here for Bel Air? Yes. All right. Do you have the affidavit of posting?
I think you have to reopen the meeting.
We're going to have to reopen the meeting. Motion to reopen
Move
the
to
meeting
reopen
for
the
the,
meeting.
Second?
all those in favor?
Aye.
Aye. Opposed, so ordered.
Okay.
Would you give the affidavit of posting there to the,
Yeah. If you have one. Just one.
Yeah.
This is good.
Yeah.
Okay.
The photographs too.
Okay.
all right, Blaze?
All righty. Mr. Chairman, the next item on the agenda under Part 3, Item 12, number 1046 Bel Air Estates. The applicant requests an extension of the performance bond for a period of 1 year to end on December 27, 2012, in order to obtain more time to complete construction and all necessary improvements. The applicant received conditional final approval for this 5-lot subdivision from the Planning Board on August 3, 2005. A performance bond estimate in the amount of $139,516 was approved by the board and subsequently signed by the chairman. The applicant submitted the bond monies and all related materials to the town, and the town board accepted the performance bond on December 27, 2005. Planning board approval for this performance bond expired on December 27, 2011. The applicant submitted a performance bond extension application to the planning department on January 13, 2012, at which time the application was distributed to all departments concerned for review. For several years, the engineering and highway departments, as well as the planning department, have received telephone calls and letters from the surrounding residents with complaints about the condition of the subdivision site. These issues were discussed at a meeting held in May of 2010 at the planning department, attended by the applicant and planning staff, as well as staff from highway and engineering departments. As discussed and agreed upon by all present, a portion of the outstanding public improvements were to be completed prior to the planning board approval for a performance bond extension that was already expired at that time, and the remainder would be completed prior to the performance bond extension, if granted by the board, expiring in December of 2011. Additionally, a building permit for lot number 5 would not be approved until all of the remaining improvements were completed. The items to be completed prior to the board granting a performance bond extension were finished on time, and the planning board approved the performance bond extension at the August 18, 2010 planning board meeting. A copy of that memorandum is attached to this memo. The engineering and planning department sent the applicant letters dated February 9th and March 21st, 2011 respectively. Copies are attached, reminding the applicant of the outstanding public improvements to be completed by the December 27th deadline. Since receiving the extension from the board, no further public improvements have been completed within the subdivision. The Highway Department, in their memorandum dated January 26, 2012, a copy is attached, state that they have no objection to the extension of the performance bond until May 1st, 2012, with the following conditions. 1, the developer must complete installing the concrete curbs along Morewood Drive, elevations and location as directed by the highway superintendent. 2, the developer must complete installing the 2 head walls and reshape the recharge basin located at the intersection of Morewood Drive and Bel Air Court. 3, the fencing and plantings around the recharge basin must be completed by May 1st, 2012. The engineering department, in their memorandum dated January 31st, 2012, a copy is attached, state that they concur with the highway department and have no objection to the extension of the performance bond until May 1st of this year, but do object to the requested extension date of December 27th, 2012. Further, the engineering department sent written notice to the applicant on January 18th, 2012, regarding all public improvements and administrative procedures that remain to be completed. A copy is also attached to your memorandum. Planning has discussed this request with the engineering and highway departments and concurs with the highway department's determination of extending the performance bond until May 1st, 2012. Should the public improvements as outlined in the memorandum from the highway department be completed by May 1st, the applicant could submit a performance bond extension application requesting additional time from the board to complete the remaining public improvements itemized in engineering's memorandum of January 18th. It should be noted that if the required public improvements are not completed by the May 1st date, the town attorney would commence default proceeding against the applicant's performance bond. Therefore, the planning department has no objection to the performance bond being extended until May 1st, 2012. The planning department recommends the board make this request the subject of an on-site inspection. Mr. Chairman, that is the planning department's recommendation for Bel Air Estates, number 1046.
Thank you. Would you come to the mic, please, and give your name and address, please?
Okay. My name is Angelo Pironi, and the address is 746 Smithtown Park, Franklin Square, New York.
Do you understand there the conditions there of the, that are being outlined?
Yes, I do understand that, but I only got 1 month. That's
You don't have much time.
right. We are asking for, to December 20, the end of the year, because I got more time. I'm having a lot, some problems with some other properties. I cannot deliver them.
Can't deliver what?
Other properties, like, the houses. I got stuck with it, with this economy, and I couldn't sell them. That's why, it's hard for me to, to get money together to finish on time for 1 month.
You get more than.
I'm asking a little bit more time.
You get till May 1st, 2012. That's not 1 month.
What is 2 months?
It's not a month. It's a couple of months.
Yeah, I was supposed to get money from a bank. I'm closing another project, and I want to move that money to this. If I could get a bit more time.
When are you closing on that property?
It's supposed to be by the end of March.
Oh, okay. So you'll have the money in April.
Yeah, 1 month. 1 month, I'm not going to be able to do all this. So. See, I'll be able to do, like, the curb, the fence, the sump, the head wall. One is done already. I just got to grade it. I only got to do 1 more. And then the other question for me, if I finish the road, then when I got 1 more lot there to do, with all the equipment that I'm going to bring in there, it's going to get destroyed at the second coat. So I would like to do that when I do the other lot.
It seems like the neighbors haven't been very happy with you for quite some time, though.
Which neighbors? Not
Neighbors
from
that keep calling the planning department and all the other departments.
not from Bel Air Court.
Well, then what is the memo
So-
talking about?
Some of the people.
We've had a number of complaints from the residents in the Morewood area. And in fact, right prior to this meeting, at sometime around 4:15, one of the neighbors called me up and sent me a written complaint. They said they couldn't be here tonight, and they sent me pictures of the site, and I felt it was too late to include it for this evening's meeting, but I promised the person that I would include it in the packet sent to the planning board before your on-site inspection.
Well, we're going to be doing it on-site, right?
Yes, we can. But
Excuse
I have
me.
another question.
Okay, all these people that they're complaining, because people, they drive by and just throw the stuff against the fence. So a lot of garbage gets clogged there with the wind and all that. We go there to clean up all the time. Try to keep the place, nice and neat. I cut the grass, I clean the leaves, I clean the garbage. Which the garbage is not my responsibility, should be the town, which I do it. I don't mind to do that.
Well, it looks like the problem I have is from May 2010 until now, it appears you haven't done anything. Now, that's almost 2 years.
That's my problem. We didn't do anything for 2 years. We had economy. I didn't leave any houses. I didn't do anything. I've been stopped dead with the work that I'm doing.
Yes, but when can the people that live there and around there expect for you to do something? It's 2 years now almost that you haven't done anything.
I did. No, I didn't. I keep up with the place, clean her up and all that. Yes.
Is that
That's
the
what I've been
nature of
doing.
the complaints that we're receiving? Is it simply garbage? Is that
It's
it?
property maintenance issues.
And are those ongoing?
Yes.
Because this gentleman's telling us that he's cleaning it up constantly. Is that accurate?
That I couldn't test on the regular cleaning up. I could just testify that of the 3 times that I've been to the site, we've encountered debris on the site.
See, that's my problem, because, people that just throw stuff there, we clean it up.
Excuse
I
me,
cut
Mr.
the
Chair.
grass 2 times, every month, 2 times a month I go there to cut the grass.
Excuse me, Mr. Chairman. I just want to give you a quick overview of the condition of the site for the past 3 years as I've seen it. I've been there several times, so I'm familiar with it. The majority of the complaints regarding the subdivision stem around the condition of the recharge basin, which is directly on Morewood Drive. It's at the corner of Morewood Drive and Bel Air Court. The fencing that is encompassing the recharge basin is a hodgepodge series of different kinds of fencing. It's not consistent. At one point in time, half the fencing was lying on the ground for quite some time. From what I understand from some of the residents, the children were going in the recharge basin and playing, and they were concerned they were going to get in there and get hurt. For quite some time, the condition of the interior of the recharge basin was not maintained. There was a lot of wild growth, a lot of wild trees. The head walls had not been done. Excuse me, I believe at this point in time, only one of the concrete head walls have actually been installed. The other one, if I'm not mistaken, is lying in the bottom of the recharge basin. This afternoon, right before I left the office about 4 o'clock, one of the residents who live on the cul-de-sac, who live in one of these homes, called me to complain about the condition of the cul-de-sac itself. There is a construction trailer, I believe on the vacant lot, that is covered in graffiti. There is a lot of debris piled up around the construction trailer. Apparently, the site itself is just generally unruly. There's no second lift on the road, so therefore the road is very rough. There are manhole covers sticking up out of the road. There are, drainage catch basins sticking up out of the road. And the majority of the complaint is that it's not complete. It's not maintained and it's not complete. And the overall appearance of it is that it really looks like, it's a slum, basically.
What's the status of that fence with the recharge basin right now?
As far as I know, the last time I was at the site, the fencing had been stood back up, but it had not been replaced with one single continuous fence. It's still a series of patched together different types of fencing that's keeping the recharge basin enclosed.
So this isn't only cosmetic, if you will, but it sounds like there's some dangerous situations in there.
Yes.
Okay, can I tell you something? When did you find the fence that was down? Because I've been there all the time, and I've never been the fence down. I don't know what you're talking about. And when you've been there?
I did an inspection on the property before we had a meeting at our office, which would have been in April of 2010.
Okay, and you found the fence down there? I
Portions,
don't think
portions
so.
of the fence were loose and falling down.
Not on the road, no. I never saw that. I don't know what you're talking about.
Well, we're going to be
The
doing it
fence,
on
excuse me, the
right?
fence that was down, it was on the inside, which wasn't my problem. Then the town came over there and fixed it. Somebody cut it. The town came over there and fixed it because it wasn't my problem. Somebody cut the fence. Yes, you're right. It was from the kids, but it was on the inside and not on my side.
The part there that the board there is concerned about is that for 2 years, you've known that something had to be done with that property in order to, extend your performance bond, and nothing's been done at all. There's no lift put on the road. There's the catch basin there at the highway department wants at the bottom on Morwood. And these things are things that could have been addressed over a period of, and I know and I understand your problem maybe with financing today, but there comes a point where we have to make a decision there that's going to make sure that something is going to be done in there for the people that are in there.
All right, can you give me about 3 months to do it?
Listen, we're going to do it on site. And if you haven't got your financing and some evidence there of doing something, then we're going to, in the May, that we're going to have to contact the town attorney.
Are you saying you can get all this done by June 1st? That's
Yeah,
3 months.
I will say I do it. Yeah, because I should have, I should be okay.
Well, the main thing is you need financing. Otherwise,
I'm
you're not
telling
going
you,
to do anything.
see, for 4 years, we've not been doing nothing. I had a big accident beside the point that I don't have to tell you guys, and excuse myself for that. I was, had a big problem with that. Then I started working, and the last 2 years, now I just finished 2 houses. I'm supposed to deliver like in the next couple of months.
But are you closing, like you mentioned earlier, that you were closing on one in March, correct?
Right.
So you'll
The end
have
of
money in
March.
April.
The end of March, yes.
All right.
So that's what I'm
We're
saying.
going to do it on site, and we're going to take a closer look at it because some of the other members haven't looked at it yet. But we're going, my advice to you is to get some kind there of a direction here to this board before you run out, so we don't have to tone it to the town attorney, all right?
All right, but I've been, from highway, I've been in touch with them, and I've been talking to him, because I wanted to do the curb before the winter, and he told me not to do it during the winter because it's gonna break up. So he recommended to do it after, which is now.
Well, what about the lift on the road?
The lift on the road, usually we do on the last house, that's when we do it. I'm doing another subdivision in Seaford. I'm doing the same thing over there. Then, town of Hempstead. The last lift is always when we do the last house.
Yeah, but
And
I mean, you're doing,
those manholes there, if you look at it, it's all asphalt all the way around, which nobody can trip on or anything like that.
well, how does the board feel there? I think that we ought to put some kind of a time limit on this, because if we don't there, he's going over to some other place there, and he's building some other place, and it's been no help there for this subdivision.
I agree.
We're going to do an on-site. And if you can't get back to this board by the 1st of April and give us some assurance that you've got the money to finish this site, and when you're going to do it, then we're going to have to turn it over to the town attorney.
By June, like, the gentleman said that I should be able to do it.
Do you understand what I say?
No, I understood.
Okay. Because it can't keep going forever.
No,
And
believe
we
me,
have
I want
to
to finish
have-
it too. I don't want to be there forever either, so.
Okay. Counsel?
Do the on-site, prepare a list of what has to be done, and give them a drop-dead date to
Okay.
do it.
Okay. We're going to do an on-site, and we're going to get the list to you, and then you need to get back to us as soon as possible to assure the director there and the board that you're going to do something positive besides just sitting on it, all right?
You got to show us some good faith here. The town has been pretty patient
I will
with
do
you, I
it.
think.
I promise you, all the curb, the fence, the trees, and all the manhole inside is going to be all done.
And the fencing around?
The fence. I'm going to
one
remove. I'm going to
continuous-
remove that fence. I put the new fence in. Take
one-
that out.
One complete fence going around the entire recharge basin? Is it all the exact same fence?
All the back is all done. Because we, the town was there, they replaced portion of that too, because it was cut down. He's right. That's the portion fence that was down. And we all complain about it, and they came and do it.
What's your time frame on the first phase of this completion process?
By June 1st, that portion that I'm telling you will be done.
But what do you expect to be done by, let's see, end of April?
That's,
What do you expect to get done first? Could you outline to us what you have on your agenda?
Until we
The
go there,
curves
really,
of the fence, the
right.
trees.
We are
Until
gonna go
there,
there.
it really doesn't
He
matter.
set the deadlines.
Right.
He meets
Fine.
the deadlines.
Good.
He signs off on it. If he agrees to the deadlines we give him, he either performs or it's referred to the town attorney.
Fine.
And it'll be an agreement with the planning board.
Okay?
Very good.
You understand what we're going to do now? It's not going to, we're not going to delay it a long period of time or anything. We're going to go out, we're going to do an on-site, we're going to make up a list of the things that need to be done. You're going to be contacted, and then you've got to assure us that those are going to be done in a timely manner, otherwise we're not going to go past there the May.
I promise you that all the sump will be done. All right? That's the first thing I'm going to do.
Do you understand what I'm saying?
Yes.
Okay. All right, a motion there for an on-site.
In the matter of number 1046 Bel Air Estates, motion to adjourn for an on-site inspection.
Second.
All those in favor?
Aye.
Aye. Opposed? So ordered. Thank you.
Do I have to call for an inspection, or you guys come and do it yourself?
Oh, don't worry there, we're going to do an on-site, and we'll give the report to the planning department, and then you're going to get a letter.
All right.
Okay?
Okay. So how much time I got, until the end of April?
We won't make that
Well-
determination.
Till after we go there.
We have to
It's not
go
going to
there.
take us long to get there, because we do an on-site on a timely basis there, and so you're going to hear something from the planning department. They're probably there before there, maybe even the end of March, even earlier than that.
All right, okay.
Okay? Is there anybody else that wishes to speak on this application? No. Okay. A motion there to adjourn the meeting again and go on with our correspondence.
Mr. Chairman, I'd make a motion to adjourn, which leads us into correspondence.
Second.
All those in favor?
Aye.
Opposed? So ordered.